Hello, you're watching Addleshaw Goddard's Employment Channel on the 26th of January. In today's news programme, we look at a recent case reminding employers that tribunals will look for the principal or true reason for dismissal when deciding unfair dismissal cases. We'll also take a look at discrimination in the provision of goods and services, with particular focus on recent disability and age discrimination developments. And finally, an update on the proposed changes to parental leave. A useful EAT case has been reported this week, which is a word of warning for employers that tribunals will look for the true or principal reason for dismissal when deciding unfair dismissal cases. Although it sounds a fairly straightforward issue, it's an area that we advise on regularly. In this case, Mr. Alexis, a head teacher, was dismissed for misconduct. However, after bringing a tribunal claim, his dismissal was found to be unfair on the basis that the true reason for his dismissal was in fact not misconduct, but another reason entirely. Here the school had pre-existing concerns about Mr. Alexis's capabilities, but rather than monitoring his performance and dismissing him for that reason, it chose to label his dismissal as misconduct, presumably so they could terminate his employment quicker. This was somewhat opportunistic and clearly ended up backfiring on the school. Helen Corbett, an associate in our employment team, discusses this case in more detail.
The school's board of governors in this case believed that Mr. Alexis wasn't up to the job and put pressure on him to leave. He refused to resign, but when a demonstration took place at the school in his support following a critical Ofsted report, he was subsequently dismissed for misconduct. The school alleged that he hadn't taken measures to prevent the demonstrators entering the school or mitigated the disruption. Mr. Alexis brought a claim of unfair dismissal, which was upheld by the tribunal, on the basis that the real principal reason for his dismissal was a prior decision of the Board of Governors that he should no longer work for the school because they didn't believe that he was up to the job. The school's appeal was unsuccessful. In reaching its decision, the AT looked at the true or principal reason for the dismissal. It recognised that in most cases, establishing the reason for dismissal is straightforward, but in a case such as this, where there are mixed motives or mixed motivations, it can be problematic. Deciding which was the principal reason for the dismissal may not always be easy and will be a question of fact or judgment in every case. So a word of warning for employers. If you are planning to dismiss an employee quickly to minimise the risk of claims, it's safer to avoid disguising the real reason for dismissal, for example, poor performance, with an ulterior reason such as misconduct, if that's not the principal or the true reason for dismissal. This may result in you having to defend a difficult tribunal claim for unfair dismissal, which you're likely to lose. But if you do decide to dismiss for a different reason, be prepared to present robust evidence to support an argument that the act complained of is sufficient to justify dismissal, for example, breach of confidentiality provisions or internet and email usage.
Thanks, Helen. EasyJet has hit the headlines this week for allegedly forcing a disabled man off a plane at Gatwick Airport because of safety fears. It would seem that the airline was not satisfied that he could reach the emergency exit in the event of a crash due to him being in a wheelchair. Martin Sabri said he'd flown many times before without encountering such treatment, and with the threat of a legal claim, EasyJet later apologised and launched an investigation. This comes at a difficult time for EasyJet, as it's recently been found by the French courts to have discriminated against 3 disabled passengers back in 2008 and 2009, and this resulted in fines. Again, Helen comments on the law in more detail.
The recent EasyJet cases are a stark reminder for companies of their legal obligations in respect to avoiding discriminating against people in the provision of goods and services, and how a breach of the obligations can severely damage an employer's reputation. In particular, the cases highlight that it's illegal for providers of goods and services to treat individuals less favourably because of a disability, and that reasonable adjustments should have been made to ensure disabled people can access goods and services. To recap on the law, individuals are protected against disability discrimination if they have a physical or mental impairment that has a major and long-lasting effect on their ability to carry out normal day-to-day activities. This includes having a learning disability, depression, or conditions like cancer or HIV. The law applies to all service providers, whether public, private, or voluntary organisations. It doesn't matter if the service is provided for free or for payment, so individuals will be protected from all forms of discrimination, not just disability discrimination, in a wide range of places, including restaurants, pubs, supermarkets, hotels, banks and shops. Individuals can make a claim in the county court, and the time limit for doing so is 6 months from when the discriminatory act took place, or the last time it happened if it was more than once. Individuals can get financial compensation, and the court can also ask the organisation to put the situation right. Typical awards range from £500 to £5,000.
Thanks, Helen. In terms of age discrimination in the provision of goods and services, you may be aware that the government currently allows insurers to use age as a factor in the assessment of risk, provided it's based on relevant information from a reliable source. However, from April this year, the Equality Act is set to ban unjustifiable age discrimination in the provision of goods, facilities and services, including insurance. The government does, however, want to ensure that the new law prevents only harmful or unjustifiable treatment that results in genuinely unfair discrimination because of age. The Government Equalities Office has confirmed that there will be a specific exception for the provision of financial services, and on the 3rd of March last year, it published a consultation on the scope of that extension. So clearly there will be some implications for the financial services sector in due course, but as yet these are not known. We've recently been in touch with the Equalities Office, who have confirmed that ministers are still considering the proposed age discrimination ban, along with the proposed exceptions consulted on last year, and it's not currently known when announcements will be made. As soon as we have any further information, we'll be sure to report back. And finally, a quick update on the proposed changes to parental leave. The Department for Business Innovation and Skills has confirmed that the new Parental Leave Directive, which increases parental leave entitlement from 13 to 18 weeks, will be implemented a year later, in March 2013 rather than this coming April. So, no need to amend your policies and staff handbooks for the time being. Just to recap, parental leave is a form of statutory unpaid leave available to some working parents, in addition to statutory maternity, paternity and adoption leave. Currently, it can last up to 13 weeks and can be flexible in terms of the time at which it's taken and the way it can be split up into shorter periods. So, that's all for today from Addleshaw Goddard's Employment Channel. Thank you for watching and goodbye.